Hi, everyone. Good afternoon. It's so nice to see some friendly faces out there. Welcome. Very excited to talk to you about this topic today. Our presentation, as you will see, is called What Would You Do? Ethical Dilemmas Faced by In-House Counsel. So we're going to play a little kind of game show here and hope you all are game to participate and help us figure out the most ethical thing to do in these various scenarios that you're going to hear about. Flora, if you want to go to the next slide, we're just going to introduce ourselves. I'm Anjali Srinivasan. I'm a partner here at Keker, Van Nest, and Peters. My practice is pretty varied. I do a lot of intellectual property litigation, a lot of patent and trade secret work, but also a lot of more general commercial litigation as well. And I'm joined by Flora Morgan. Flora, please go ahead and introduce yourself.
Hi, everyone. Thanks so much for your attention to our presentation today. We hope it will be fun. I am an associate here at KVP, and I work on all complex litigation matters as well.
Okay, so on to the next slide. So before we get into some of our fun scenarios that we're going to throw at you all, I thought it would be helpful to talk a little bit about the kind of ethical framework that we're all operating in, both outside counsel, but in-house counsel as well. You have to think about, you have kind of three masters here. You have your ethical obligations to your client. And so for us, that is often you and the company. And often for people in-house, there's the client, there's the company that you represent, that you work for. There could be internal stakeholders that you might think about as your clients as well. There's also your ethical obligations to the court. And there's also ethical obligations to your adversary in litigation. And sometimes those three things can come into conflict, and you have to kind of pick a course of action that still satisfies all your various ethical obligations. So we'll talk a little bit more about how that can happen. So starting first with the ethical obligations to the client. One of the very important ethical obligations that we think about a lot as outside counsel is the duty of zealous representation. We have to act with commitment and dedication to your interests. We want to do what's best for you, the client, and we have a duty to the client and to the legal system really to represent you as zealously as possible. And sometimes people think about that as kind of doing everything the client wants, but that obviously is within reason and subject to some of the other ethical obligations that we're going to talk about as well. Moving to the next slide, one of the other ethical obligations that lawyers have to their clients is the duty to maintain confidentiality. You'll see here a citation to the California Business and Professions Code about the duty of an attorney to maintain the confidence and at every peril to himself or herself, very dramatic language here, to preserve the secrets of his or her client. There's an exception noted here, a pretty important exception, that an attorney may, but is not required to reveal confidential information if that disclosure is necessary to prevent a criminal act that is likely to result in the death of or substantial bodily harm to an individual. Probably not something we all encounter in our practice, but important to kind of think about the tension there between sort of zealous representation, confidentiality, but obviously there are limits to all of this, and you can think about this as a limit that kind of exists sort of in the world of ethical obligations to the court, to society, you might say, that kind of limits the scope of what you owe to your client in the way of confidentiality. The next slide talks about some of the ethical obligations you have to the court. The duty of candor, for example, is one of these obligations. And the idea is you have, for example, you have to disclose controlling legal authority known to the lawyer to be directly adverse to the position of the client. So when you're thinking about zealous advocacy, As your lawyer, I would love to go up there and argue whatever you want me to argue on your behalf. But if, for example, there is a case that is directly opposite to the point that we're making, I have an obligation to disclose that there is controlling legal authority to the contrary. So you can already begin to see some of the tensions there between zealous advocacy for your client, but you also have a duty of candor to the court. A lawyer in this sort of same vein must not make any false statements to the court, offer any kind of evidence the lawyer knows to be false. So as part of your zealous advocacy, there is sort of a bound to that, and you can't be running afoul of your ethical obligations to the court, your duty of candor. And then there's also the duty to, you can go to the next slide, Flora, the duty to remediate. Now, let's say a lawyer becomes aware that material evidence offered to the court is false. The lawyer has to take reasonable remedial measures, including, if necessary, disclosure to the tribunal. But the lawyer must still abide by the duty of confidentiality to the client. So you have to maintain confidentiality, but there's sort of a limit there. If you know something is false, you do have a duty to not only not admit the evidence, put it before the court in the first place, but if you find out about it after the fact, you do have a duty to remediate that issue and present it to the court and raise it with the court. So now let's take a look at some of the ethical obligations to the adversary, which I think we often forget that we have ethical obligations to our adversaries, but we do. And Flora, why don't you cover this?
Yeah, so, and these ethical obligations also apply to in-house legal teams, not just outside counsel. So as a refresher, it's important to remember as lawyers, we must not obstruct access to evidence or a witness. We must not destroy or conceal documents with evidentiary value, and that actually carries a potential criminal penalty. So it's really important to be aware of those litigation holds and making sure that you're preserving documentation in anticipation of litigation. And we also cannot suppress or falsify evidence. These seem kind of obvious, but in the process of litigation, sometimes some of these, there may be some gray areas that it's important to just make sure that we are abiding by these rules. We also have a duty to bring only meritorious claims and defenses, and we really cannot use litigation as a tool to purely harass or maliciously injure someone, whether that's in bringing an action itself or asserting a defense. And we also have a duty not to unduly delay. And really this comes down to making sure that we're not prolonging proceedings or causing needless expense to our adversary. One thing we don't have here on the slides that I think is important to mention as well is the general sort of no contact rules that we have as attorneys not to reach out to represented parties actually don't apply in most cases to in-house counsel. So your opposing counsel can reach out to in-house counsel, and they kind of are caveated from those rules. So it's obviously important to check that this is the same in your jurisdiction, but that is that one thing that is sort of a little bit different for in-house counsel that's important to mention. So now we're going to transition into the fun part of this presentation. We're going to run through 4 different scenarios where we sort of put ourselves in the shoes of in-house counsel faced with difficult ethical dilemmas. And then we're going to turn it over to all of you to let us know what you think the best option would be. I'll pass it back to Anjali.
Great, thank you, Flora. So we'll start with this scenario, and maybe this applies to some of you, and hopefully you've not encountered this exact situation, or if you have, hopefully you picked the right choice. I guess we'll find out. So you're representing a small company and you're in-house. It's a small startup, kind of everybody knows everybody, everyone's scrappy, wearing a million hats. You're helping the company negotiate a deal to be acquired. And part of the deal involves equity and some non-compete terms that would apply to the company's founders. Now, one of the founders asks you to explain the deal terms to her and then asks you if she should sign the deal. Who do you represent, though, at that moment, and should you answer this founder's questions? So let's do a little poll. We'll go to the next slide. These are your options. So option A, you represent both the company and the founder because she is a key stakeholder. You may explain the deal terms and give her legal advice as long as her interests align with the company's. B, you represent the company, not the founder. You may explain the terms objectively, but you can't advise her on whether to sign or not unless the company specifically allows you to represent its founders and there's no conflict of interest in representing both the company and the founder. C, you represent the company, but you may advise the founder on whether to sign because she's a company executive and your role includes supporting leadership in business decisions. And D, you represent the company and you should not explain the terms or offer any advice because doing so could create an attorney-client relationship with the founder, violating your duty of loyalty to the company. So I'm going to give everyone some time to take a look, lock in their votes. And I know we have a lot of text on the slide, so some of you might just need a minute to read it as well. Okay, so it looks like a pretty large group of you went with option B. A few folks, though, C and D, and nobody chose A, which I'm happy to see. And let's talk about why I'm happy that people didn't choose A, but we'll talk through some of the considerations at play here. So the general rule is that a lawyer who is employed or retained by an organization has to think about their role, conform their representation to the concept that the client is the organization itself. But of course, a client, an organization, a company really only acts through authorized directors, officers, employees, members, shareholders. The company itself is really just a collection of people. But the employment and the client here that you all have is client relationship is with the company. And this is true even if your legal advice might have some impact on principals, on the founders at issue here, on the directors or officers. And this is true even in the context of a small, closely held corporation. So this is the general rule about your employment, your kind of duty of loyalty and who you represent. It's always the company. But, and we'll go to the next slide, there are kind of some complications here. If you are an attorney for a closely held corporation, you may owe professional duties to certain individual owners. And so you have to think about, are these individual owners ones that you've had kind of close interactions with? And there's a lot to sort of factor in here. Is this a very small startup of 3 founders or five employees? Are we talking about an 80-person organization? What is the extent of your contact with these individuals that are maybe coming to you for advice? And what is the attorney's access to information relating to the individual owner's interests? So this is kind of a different point, but if you were asked to advise the founder whether to sign, you might need to get more information to actually give solid advice. And if that's the case, you want to definitely think twice before offering some kind of recommendation at all to that founder about what to do. If you don't really know the ins and outs of how that founder is impacted, what the terms of their kind of equity interest is in the company, how it would be impacted. So that's kind of another thing to keep in mind. So moving to the next slide, Flora, just to kind of summarize here a little bit, your client is the company, not the owner. Explaining the deal terms to the owner, that might be okay. You're talking about what's happening to the company, what is the deal, what is at issue. if the founder is simply asking you what does this mean? Does this mean the company's going to be sold for $5 or $10? You can explain that would make sense. But advising the owner about whether she should sign, that sounds like something that's going to be more about the individual circumstance. Do you have enough kind of information and knowledge to be able to answer that question? Is this someone who you've had sort of close interactions with in a small company setting? A lot of this kind of hinges on being clear about those rules and being clear about who your client is and being clear about the communication advice that you're giving. So making sure you're caveating your response. I represent the company. Here's what the deal would mean for the company. And I can't advise you on whether or not to sign because A, B, and C, if that's true, or if there's a situation where you might be able to offer that kind of advice, depending on the scope of the representation and what they're asking, it's possible. Again, you also always have to be careful about potential conflicts, consent rules. If you think that there's a potential conflict between the owner and the company as a whole, you'd want to think about that as well. So I think the next slide gives us the answer to our poll, which an overwhelming majority of you selected. I believe 85% of you went with option B, which is great. You represent the company, not the founder, and just an important thing to keep in mind. You could explain those terms again objectively, but probably not a good idea to advise her on whether or not to sign unless we're talking about, I can imagine a scenario with a very small company, a kind of mom and pop or something like that, and they want to know how does this benefit me, or what's going to happen to my interest. And in that case, you might be able to provide that information. Again, you'd really want to think through, are there any conflicts here? Is there any potential conflict here such that I should maybe not offer that advice? But the deal terms, again, are fine to explain. And for some of you who chose option D, I appreciate the caution exercised by the folks in option who chose option D, but option D probably fine to explain what the deal terms are in a closely held corporation like this, and a closely held kind of startup company. People may want to know, like, what does this deal mean? And if you're answering questions like that, you're still fine. Okay, great. Shall we go on to the next scenario, Flora?
Yes. So our scenario 2 focuses on working at competitor companies and lateraling from one place to another, and how that might create ethical issues down the line. So in this scenario, you are once again in-house counsel at a company called Alpha, which is a patent licensing and enforcement company. You're overseeing a patent infringement lawsuit against Beta, which is a competitor to you, and you've partnered with outside counsel law firm LLC. Your boss is the associate general counsel, and she previously worked as an IP attorney at Beta, the competitor that you're suing. She claims she had very limited involvement with the patent at issue during her time at Beta, which was over 7 years ago. But she says, I may have been in some meetings where the patent was discussed. I really can't remember. It was such a long time ago. She has been screened and walled off from this case and is not directly participating or advising on the litigation. So our question is the conflict of interest imputed to you from your boss? And can you represent Alpha in this matter, or are there ethical concerns you should evaluate before proceeding? So I'm going to tee up poll number 2 here and show you all our options for A, B, and C, and D. And I'll just walk through them as you all read the text on the screen as well. So A is yes, the conflict is automatically imputed to you because your boss is part of the legal team at Alpha, and her prior work at Beta creates a conflict of interest that extends to all in-house counsel under imputation rules. You must notify Beta and withdraw the lawsuit. B is no, the conflict is not imputed to you because your boss is not actively involved in the case, and she was only minimally exposed to the patent at issue over 7 years ago. She has since been screened, so you don't need to take any additional steps to address the potential conflict. You can continue to represent Alpha in this lawsuit. C is yes, the conflict is imputed to you because your boss was previously an attorney at Beta. and even minimal past exposure is going to create a material conflict for you. And these ethical rules extend broadly to in-house legal teams. And then option D, which I see many of you are leaning towards, no, the conflict is not automatically imputed to you, but you should take additional steps to ensure proper screening measures are in place, notify beta if necessary, and confirm that your boss does not provide any indirect input on the case given her role. You can continue to represent alpha as long as the screen is effective and beta does not challenge it. So I'll give you all a few more seconds to put in your selections here. We have a strong winner in option D with 90% focused on that option. B and C are kind of tied. Okay.
We have a lot more people on here than those who are participating. So I encourage all of you to just vote, just, take a gander.
Yes, please do vote. It will make it more interesting for us to discuss this once we get to Q&A at the end. So let's review kind of the rules that might come to mind as you're thinking through this question. First, Rule 101A is really the number one on point here. And specifically, while lawyers are associated in a firm, which includes in-house legal departments, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so. And there's a few exceptions and caveats to this rule. First, if the conflict arises out of a personal interest of the prohibited attorney, then, if the conflict that's personal does not represent a significant risk of limiting the representation, then that would not constitute something that would be imputed to the rest of the law firm or in-house counsel department. And then secondarily, if the representation is adverse to a former client, which is the situation we have at hand here, and the prohibited lawyer from the prior law firm did not substantially participate in the same or the related matter when they were at the other law firm or in-house counsel team, the prohibited lawyer is timely screened, meaning that includes that they're not participating and they would not receive any fees from this representation. And if written notice is promptly given to the affected former client, then once again, that's not an issue that would be imputed to the rest of the legal team. Some of the comments on this rule, I think, shed light on the gray areas between the factors you'd want to consider here, specifically all of the text here that's in bold, to determine if potentially prohibited lawyers' previous participation was substantial. You might want to look at the level of responsibility they had on the prior matter, the duration of their participation, the extent to which the lawyer advised or had personal contact with the former client, and the extent to which the lawyer was exposed to confidential information, which is a very important piece here as well. Even if they didn't have a lot of contact, if they had access to confidential information that is now material in the current matter, that would create a real ethical issue. And then the standards for disqualification and the effectiveness of screens are subject to statute and case law. So it's important to make sure that as you're thinking through this, are there any opinions or statutes that govern how this should play out? There is a carve out for work lawyers did before they were barred. So if you were in law school working at the opposing counsel's office, that would not be included. Or if paralegals or legal secretaries did work with the defendant in this case, that would also not be imputed directly to the attorneys. We thought it would be helpful to give a little bit more time here to ethical screens and specifically, what's important to have when you're screening out conflicts and evaluating whether or not there's going to be some kind of ethical issue around representation. So the California Rules of Professional Conduct now expressly allow for the use of ethical screens to avoid an imputed conflict without client consent in some cases. So that's important to know. Sometimes that is, the best first place to start and maybe the end of the conversation as well. This was previously only recognized in case law, but is now officially part of the Rules of Professional Conduct. some of the key elements to have in an effective screen, because if you're screening, it really comes down to what it is, what actions you're actually taking, and not necessarily whether there is or is not a screen. So some of the elements that we found to be quite effective here, timely screening, which usually means at the point of representation. Screening a lawyer out means, like I said earlier, you cannot share fees and you cannot be involved directly or indirectly in the representation. There should be notice to all of the affected clients. And of course, there's prohibitions against communications across the screen. That is the whole point of screening lawyers out of this, being able to touch this litigation. There's also this sort of reciprocal limitation on access to information. So in one direction, that means the prohibited lawyer cannot share their information broadly with the firm or the in-house counsel team. And in the other direction, the prohibited lawyer should not have access to any information on the ongoing matter either.
I just wanted to note one thing. When you had the rule up, Flora, the rules kind of talks about a law firm when lawyers are associated in a firm. And the rules then go on to talk about a firm as kind of what we think about as a law firm, a law partnership, but also a legal department in a corporation. And so when I kind of read this rule and thought about it, I obviously think a lot about conflicts in the work that we do at a law firm, but thinking about how this could apply in-house, we thought was really fascinating. People are moving around a fair bit from company to company in-house, and thinking about how this would work in-house, and it sort of surprised me. It was an area that I kind of didn't think, oh gosh, this must happen a fair bit, and how are these conflicts handled? And then another thing is kind of thinking about screening when you have a sort of supervisory managerial role. So in this case, the person was the AGC, and you need to make sure that whatever screen you have actually goes sort of all the way up and walls that person off, because they also just, they can't be at the supervisor's meeting or the whatever meeting, the all hands meeting where that case is being discussed. So really thinking about an effective screen that's going to impact a pretty senior person potentially in an organization. Sorry, Flora, didn't mean to take us off track.
No, I think that's all helpful context and great segue. So as Anjali said, timely and thorough screening, making sure it goes all the way up if necessary, and really thinking through, are there any potential moments when this person who's screened off may have access to information that's not as direct as attending the team meeting for that particular matter. Again, as Anjali said, the firm is not just a typical law firm that we think about, not just outside counsel, but also in-house counsel. All of these rules apply to in-house lawyers as well. And then there's a few cases. There's one out of California that have held that there's a rebuttable presumption that if a party's lateral in-house lawyer formerly worked at the opposing party's company, then they have shared that opposing party's confidential information with their current employer. And that is huge, obviously, and an important thing to think about in our particular scenario here, because if there's already this presumption that there's going to be an exchange of information that is unethical, it's even more important to make sure that if this is challenged in court, that you have a record of all of the steps that were taken to ensure that that did not happen.
And probably doing that kind of right at onboarding.
Exactly. Another example that we kind of loosely created this hypo off of was this case Dynamic 3D Solutions from a few years ago, where an entire in-house legal department and their outside counsel, were disqualified from working on something following a lateral hire. And here in this case, the plaintiff, had the lateral attorney who had worked at the defendant's company. And even though they tried to rebut that presumption that we previously spoke about, they were unable to do so because the court found there was evidence that despite the screening, the lateral lawyer had participated in meetings and actions related to the litigation against the defendant. So again, just to emphasize the points we've been making here, really important not only to have a screen, but to really make sure that the method of screening is well outlined and well observed, and that if a conflict like this is challenged in court, you have all of those things dating back to the point of representation or the initiation of litigation to show there has been no crossing of the screen here. Okay, so the reveal of our poll here, 85% of you were correct that option D, that the conflict is not automatically imputed to you, but there are lots of additional steps you should take, was correct. We also had a few of you who voted for B and for C, just to kind of give a little bit of insight onto those answers. B is close. It's just a little bit looser on what else you should do in addition to having the screen. And so we put this in here kind of to trick you all into picking it because it does seem more or less correct, although the operative words there are, you do not need to take additional steps to address the potential conflict. And we're trying to hit home on that point.
I was fooled by B when I first read it. Almost chose it myself.
Yes. And C, the conflict is imputed to you because your boss was previously an attorney at Beta. Again, I think this is a good first place to start, that there is a lot of potential for conflict here. And so it's even more important to make sure that you're doing the right things to resolve any imputation issues. Okay, I think we're moving on to 3.
Okay, so this is something probably a lot of you might be doing right now, California lawyers working outside of California. In this scenario, you are a California licensed attorney. You're working remotely for a tech startup that's based in Texas. The startup often asks you for your advice on California-specific legal matters, such as employment law and contract disputes, but they sometimes do ask you about Texas-specific contracts and ask you to provide guidance on local Texas regulatory compliance issues. You, though, are not licensed to practice law in Texas, but you feel pretty confident in your ability to research and address these issues. Seems pretty straightforward. What could go wrong? Now, the question is, are you engaging in the unauthorized practice of law by advising this company on Texas-specific matters? What steps should you take to comply with California's ethical rules and multi-jurisdictional practice guidelines? So here's the scenario, here's your options. Now, are you engaging in the unauthorized practice of law? If you give advice on Texas-specific matters, you're California licensed, not Texas licensed, and what steps should you take to comply? Option A, no. As long as you clearly disclose that you are only licensed in California and base your guidance on general legal principles, you're not engaging in the unauthorized practice of law in Texas. You may continue advising on Texas-specific matters. Yes, advising on Texas-specific contracts and regulations without a Texas law license constitutes the unauthorized practice of law. You must either obtain a Texas license or refrain from providing legal guidance on these issues. C, not necessarily, but to comply with ethical rules, you should limit your advice to California law and recommend that your company consult Texas licensed counsel for state-specific matters. You may provide general contract analysis, but should avoid interpreting Texas statutes or regulations. And answer D, no, because you're employed by the startup as in-house counsel, and California multi-jurisdictional rules allow in-house attorneys to advise on all legal matters that are relevant to their client. There are no restrictions on your ability to provide Texas-specific legal guidance as long as you believe you can competently do so. I'm going to give everyone a little bit of time to participate in the poll. I think there are a lot of answers here that we wish were the correct one, because it would probably make our jobs a lot easier and allow us to say yes and get a lot more things done, but unfortunately, we are limited by our licenses. Okay, looks like a little over 50%, 60% going with answer C, 62% with answer C. But a strong group of people going with answer D, and a few with answer B, and then one with answer A right now. So let's take a look at some of the rules that apply here, and let's talk about the multi-jurisdictional practice guidelines. And before we get to that, I want to talk about this idea of California lawyers working outside of California. I think this is happening much more often. COVID has really changed the way we practice law. It used to be if you were working at a Texas startup, they'd say, great, you have to show up to work in Texas, and probably more Texas licensed lawyers would be the ones taking those positions. But now remote work is common in a lot of industries, and California lawyers who might be working for California firms want to live and work in other states and vice versa. There could be people working here, based here, but working for a company based elsewhere. So you need to think about a lot of different things when you're thinking about ethical rules and which states' rules apply to me, depending on where I work or who I work for, or what kind of legal practice and legal advice I'm providing. So going to our next slide. The ABA issued a formal opinion in December 2020, very timely after COVID and kind of the rise of remote work. The opinion says, in the absence of a local jurisdiction's finding that the activity constitutes the unauthorized practice of law, so kind of deferring to the local jurisdiction, a lawyer may practice the law authorized by the lawyer's licensing jurisdiction for clients of that jurisdiction while physically located in a jurisdiction where the lawyer is not licensed. So you can be outside of California, but be barred in California, admitted to practice in California, and be providing legal advice practicing California law, even if you're not physically located in California. But that is so long as the lawyer does not hold up the lawyer's presence or availability to perform legal services in the local jurisdiction, or actually provide legal services for matters subject to the local jurisdiction where they're located, unless otherwise authorized. So you want to be careful not to start holding yourself out as a Texas lawyer because you're located there if you're not actually licensed there, and haven't actually gone through the steps to be licensed there. You need to be a little bit careful here. So let's go to the next slide. Let's talk about California's rule for California lawyers that are practicing elsewhere. So if you're a lawyer admitted to practice law in California, this rule applies to you. These are the California rules of professional conduct. And these rules state that a lawyer admitted to practice here shall not practice law in a jurisdiction where to do so would be in violation of regulations of the profession in that jurisdiction. So if you're a California lawyer, you're located in Texas, you need to be careful not to be doing something that's going to run afoul of whatever the Texas regulation of law practice is. And you also can't knowingly assist a person in the unauthorized practice of law in that jurisdiction. So that may mean you can't sort of supervise someone else in engaging in Texas legal research if that person is not authorized to do that kind of Texas law practice either. So you need to think about what's Texas's rule against this, but also think about how that's going to apply to you based on the California rules of professional conduct. You do not want to run afoul of a rule that's going to affect your law license and your ability to practice law and your admission to the California bar, and you could. So it kind of asks you to take a look at the local jurisdiction and see whether it would violate the regulations there. And so then let's look at what some of the other states' rules say about a foreign lawyer, foreign meaning from another state working in the state. Many states have a rule similar to Rule 5.5b of the ABA model rules. So this is what 5.5b says. A lawyer who is not admitted to practice in this jurisdiction shall not, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, or hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. So you can think about in our scenario, Texas and many other states do have rules similar to this. So you want to be careful about holding yourself out in some way to the public, but it could even be internally to your company that you are licensed to perform this kind of work, licensed to practice law in Texas. And you need to be careful. Again, you may not just run afoul of Texas's rules, but you might actually put your California law license at jeopardy. So let's take a look at the next slide. There's a California State Bar formal ethics opinion. This was issued just a couple of years ago, sort of recognizes that lawyers might temporarily relocate to another state, and again, encourages lawyers to consult the multi-jurisdictional practice and unauthorized practice of law rules and authorities of the state where they are physically present. So make sure you're aware of what the rule is where you are located, and where in this scenario you're being asked to maybe provide some legal advice about, but make sure you know what those rules are, because it could impact you and your law license here. And then there's a little more in the formal ethics opinion what the ABA and other local ethics committees have sort of issued on this. So the next slide, kind of our takeaways here. Rules in California and other states allow you to live and practice while you're located elsewhere. You can still practice California law living outside of California, and many states have similar rules kind of formally permitting a lawyer to locate outside of the state but still practice that state's laws. But you want to be very careful and check the local rules for the jurisdiction where you're located and follow those. It says here, as the rules develop, because a lot of this could change over time, especially if local if jurisdictions start realizing, oh, this is becoming a problem. We have an influx of California lawyers come into Texas and they don't really know what's going on here and are kind of engaging in Texas law, and they're doing it wrong and they're screwing it up. You could see a little more enforcement of this, or you could see more rigid rules being kind of implemented to address this problem. And then, of course, just consider taking or passing into the local bar if this is something that is coming up a lot in your work. So let's take a look at our correct poll answer, answer C. The answer is not necessarily, but to comply with ethical rules, you should limit your advice to California law. And the moment you're being asked about kind of Texas specific questions, you don't really want to be engaging in that. That kind of looks a little too much like the practice of Texas law. Now, quite a few of you chose answer D, and I really admire those of you who chose answer D and feel like I can do anything. I'm a lawyer. I just got to research it and I'll figure it out. I understand the impetus there, and I understand particularly wanting to be really helpful to the people at your startup who have a legitimate question, but you want to really think about whether that's a good idea. There are actual restrictions on your ability to provide this specific guidance, and your California law license is at stake. So you may want to, you might be capable in some ways of doing that research, but you are not licensed to practice Texas law, and you certainly don't want to be engaging in the unauthorized practice of law. And then looking at B. So B is almost could be a little bit too rigid in some ways. I think you were able to provide some kind of general contract analysis, which is what Section C allows. I think that could be okay. But if it's something very Texas specific, again, you'd want to be careful. So that's just the distinction between B and C. It's maybe just a little too narrow. But B would be also an ethical option to choose, and probably not going to lose your license, but you might annoy some people at your company. All right, let's go on to scenario 4, our final one.
Yes, and a CLE on ethics would be remiss to forget about AI and not discuss this. Obviously, AI is changing a lot of things, a lot of ways that folks work. There's some inroads here with legal practice as well, but it's important to really understand what is probably the grayest area we have talked about today, and how our ethics rules really govern what we can and cannot do, and how we can and cannot leverage artificial intelligence. So here you're in-house at a small startup that's highly cost conscious. So, really trying to push out products and not spend a lot of time or money on legal fees. But they do have in-house counsel. And the CEO wants to understand data privacy compliance for a new product launch. And they ask you to do some preliminary research before engaging outside counsel. To save time and to also save costs, you decide to use a reputable AI chatbot with a deep research function to explore the question. The chatbot provides an insightful response, as they usually do, which you review and you assess as approximately 80% accurate. So you consider sending this initial research to outside counsel for verification and refinement. Our question is, can you rely on AI tools for preliminary legal research, and what steps should you take to ensure compliance with ethical obligations when doing so? So once again, we're going to launch our poll, and we've had about 50% of you active on these polls. So I'm going to leave this one open a little bit longer in the hopes that folks will participate on this one a little bit more. So option A is no. Relying on AI-generated legal research is ethically problematic because AI tools can produce inaccurate, misleading, or hallucinated results. You should conduct your own legal research, not using AI tools, or engage outside counsel directly instead of using artificial intelligence as an intermediary. Option B is no, because AI tools may not be designed for legal research and could expose you to ethical risk and your client to embarrassment if you or outside counsel are misinformed by the AI results. Even if you verify the output, it's not advisable to use AI for legal research unless the tool is designed for this use. Option C is yes, AI can be a useful research tool, and as long as you review the output critically before relying on it, there's no ethical concern. You can share the AI-generated research with outside counsel for confirmation without additional precautions. And option D, which I see is the fan favorite here, yes, but AI-generated research should be treated as a starting point, like a Google search, not a final source. You should independently verify the information using authoritative legal sources and disclose any AI usage to outside counsel when seeking their verification. Give folks a few more minutes while we have these up on the screen to make their choices. 22 of you have voted. There's 45 in the room. Maybe if you haven't participated yet, this is the one you want to join in on. Okay, like I said, I'll keep the poll open just so folks can continue to vote for a minute or so. So just by a show of hands, and you can raise your hand at the bottom. I think it's in reactions. You can raise your hand there. How many of you have used an AI chatbot for any use? Doesn't need to be legal research or anything like that. Okay, we have a few folks. Great. Looks like 4 of you have used it. I have, maybe 5. So maybe 6 of the 45 of us have used, actually maybe more like 10, have used an AI chatbot, which is great. It's good to experiment with new technology. For those of you who haven't used it, or who, maybe you don't know too much about how chatbots work, just as a kind of overview, this is the landing page of Claude, which is Anthropic's version of an AI chatbot. And really how they work is they're computer programs that simulate human conversation with an end user using a technology called natural language processing. We don't have to get into the technicals of how that all works, but essentially what they're doing in the background is looking at patterns in words that come out of a huge database of information, and they're feeding back to you what their sort of high probability results are based on those patterns. So they're very interesting to interact with. I highly recommend if any of you have not had the chance to work in with one of them, that you should. It's just interesting. But to get to the sort of potential uses for us and for this particular hypothetical, we've caveated here that these are potential uses for AI in legal work eventually. A lot of these tools are still being developed and changing almost on a weekly basis. And so some of these things are kind of more robust at the moment, and some are coming in the future. But the types of tasks you can do include legal research, document review. Summarization is probably one of the strongest tools that you can use right now, these chatbots for. And then these last three, we've put some question marks because we don't really feel confident that there's any tools out there that are doing this kind of work really robustly yet, but it's coming in the future, and that would be fact research or investigation, risk prediction, and drafting pleadings. So there's a lot of companies that are working on these different tools, and they're focused on how they can make tools that can allow us to do our jobs as lawyers much more quickly and efficiently. But what are the risks? There are a few of them. So first and foremost, AI chatbots are designed to sound confident when they give you a response. But they may be hallucinating, they may be making things up, they may be just flat out wrong, but it will sound very much like something that's credible. Some just screenshots of headlines recently from last month. The first here is about hallucinating AI and how that can really cause an issue if you're using AI to generate maybe citations for a brief. For example, we are at the 42nd law firm now that's been sanctioned over fake case law. And so this is really something that can become not only, damage your reputation or damage your firm's reputation or your company, but also something that can be a real risk in terms of strategy when you're litigating. This is not something you want to have to discuss in front of a court.
Yeah, the little blurb there says that the firm cited 8 non-existent cases, at least some of which were apparently generated by AI. So you certainly don't want to be coding cases that are not real.
Yes. And someone very helpfully recommended a helpful AI tool in the chat called GC AI platform. This person says it's been a game changer for them and a number of their GC CLO colleagues. So that might be one to check out. Sally, were you raising your hand to comment, or is that just a hand from the prior question? Okay, keep moving.
Prior question.
So the information that you put into chatbots as well may not stay confidential. So this is definitely something to be aware of when you're experimenting in your day-to-day work, and with the hypo that we presented might be an issue if the product is, confidential, has not been launched yet, and there's information about the product that your company doesn't want to get out to competitors. Another quick headline here from a few years ago, but Samsung actually banned use of ChatGPT just within a year of its launch because employees were using it such that sensitive data was actually leaking into the system and coming up in responses that ChatGPT was spitting out. And just to kind of run through a few of the rules that are pertinent to keep in mind here, there's a lot of text on these next few slides, and in the interest of time, I won't spend too much time running through each of them, but just to give a sort of high-level overview, obviously the duty of competence is important to keep in mind here. It is our responsibility as attorneys to do the work to be able to provide competent legal services. And we obviously cannot shirk our professional judgment or the sort of learning process to a tool that may or may not be giving us accurate information. And there's some more elaboration here on how those rules give guidance on artificial intelligence use. And specifically, I thought here in red, the duty of competence requires more than just mere detection and elimination of false AI-generated results. So if you're using AI and you're thinking, I can use this because I reviewed it and there's nothing that's kind of false or untrue, you really should think about taking that extra step to stay in accordance with the ethical rules, to really do your own due diligence and then cross-check with what the AI tool has spit out. We already talked slightly about the duty of confidentiality. Obviously, this is really important for sensitive, confidential, privileged client information. You wouldn't want any of that to get into a tool that is either free or maybe you pay for with a subscription, but is not what's called an enterprise tool, one that's not kind of cabined to your legal team. And then supervision and unauthorized practice of law. These are also rules to keep in mind as well. If you are a more junior attorney and your supervising attorney says, hey, just use ChatGPT to figure out that legal question, it is still your responsibility as the more junior attorney to not just take those directions without considering the impact of the ethical rules. And here we just have a little bit more elaboration of what I just ran through. But I think all of you are going to get the slides after this, so you can always refer back to these. Just to touch on quickly, what does the California State Bar have to say? This executive summary I thought was really helpful. It came out sometime last year. This first sentence of the second paragraph, I think, really sums up how dynamic the situation is right now, and specifically the second line, even for those who create generative AI tools, there's a lack of clarity about how it works. And I think this really brings home the idea you might have in your mind as you're thinking about this. Can I support this in front of a judge? Can I support this in front of my clients? Is this going to be a good thing for me to present to the CEO? You really want to be able to say, I know how we arrived at this answer. And unfortunately, with AI, it's not always clear where the sourcing is coming from, what the authorities that they're citing are, if they're real, if they're not. And so all of these things are important to consider. So our takeaways, do not put confidential, privileged, or non-public information into chatbots. You will be sorry. You may be on above the law or something else like that. If you use AI for legal work, do some with extreme caution, especially if it's a tool you're unfamiliar with. Really just take your time to understand how it's working and fact check everything. You cannot delegate your professional judgment to another person, never mind technology. And really take the time to set policies and conduct trainings in-house to make sure that your team is all on the same page about what you can and cannot use these tools for. And things are changing really quickly, so keep up to date on these new kind of ways you might be able to employ these tools, and also any of the risks associated with that. So our final reveal here is that most of you were correct, 96% of you. That answer D is the right one. I think it's helpful to think of AI-generated research as like a Google search, something that gets you going maybe in the right direction, but that certainly needs further research and further diligence to rely on. It's also just a good rule of thumb and best practice to disclose to your team internally and externally when you're using artificial intelligence, so that folks know how to handle that information with the requisite amount of care. One person selected option C, which is, I think, also kind of one of these tricky ones. It is similar in that, yes, you can use the AI tools, but the caveat here is that we said without additional precautions, and that's really the number one thing here, is to make sure that you're using these AI tools responsibly. And so definitely don't run any queries and do a sanity check and think that's enough. It's definitely important to make sure that you are cross-checking with further research and using authoritative citations for that.
And there was a great comment in the chat, kind of identifying these as issues of attorney judgment, review, and competence. And I think we completely agree. I don't think that AI changes everything, but I think that there may be a view that it does. And I think that's the problem, that we can't just think of AI as perfect and all-knowing, and we just need to be responsible about how we use it as one of many tools in our toolkit. Okay, I think that about does it. Thank you all so much. Apologies for keeping you a couple minutes over. And I don't know if we have any time for questions. I don't know if we have any questions. I feel like at the end of the day, maybe people are looking to get out of here, but if anyone has questions, we're happy to talk more. Okay.